Hello and welcome to the BLC box. My name's Steve Terrett and I'm delighted today to be joined by Professor Catherine Barnard, who is a Professor of EU Law and Employment Law at the University of Cambridge. She's also a Fellow of Trinity College and she's the college's senior tutor there. Now, Professor Barnard really doesn't need any introduction. I'm sure anyone who has anything to do with law has come across her, or at least her work. She's written extremely widely on all aspects of EU law. She's written what many people, including myself, consider to be the Bible of EU substantive law. So it's a great pleasure professionally to be talking to you, but I'm lucky enough to be able to say that it's a great pleasure to have known you for the last 20 years, from when you first came. I first met you when you came to teach at the British Law Centre. And she's been many, many times since then. And I hope that she'll be coming for many, many years to come in the future. So Catherine, hello, thanks for joining us.
Well, thank you for that very warm introduction. And I say it will be my pleasure to come and work at the British Law Centre and obviously work with you and your wonderful colleagues, and perhaps even more importantly, the excellent students that you have coming through your doors.
Absolutely, absolutely. And our students have been harassing me already to say, when can we see the Professor Barnard video? So I'm glad that they'll finally be able to watch this now. I was planning to begin by saying that COVID-19 had kicked Brexit off the headlines for quite a while, but now it's maybe a time for focus on Brexit to return. And then something else comes and kicks Brexit off the headlines, which is a German Constitutional Court judgment from last week, which has gone viral, if that phrase is still an appropriate one to use. But the PSPP judgment, could you maybe explain to us, in essence, what it's about and what the potential ramifications of the case could be?
So it's not often that in the UK we'll be talking about a judgment of the Bundesverfassungsgericht, the German Constitutional Court, not least because it's about quantitative easing in the Eurozone. And of course, the UK, like Poland, isn't in the Eurozone. But in short, the judgment basically says that the PSPP programme, which is a type of quantitative easing of the European system of central banks, is ultra vires, i.e. beyond the powers of the ECB, the European Central Bank, because the ECB hasn't demonstrated the proportionality of the decision to launch this quantitative easing programme. Now, all of that sounds rather technical and not terribly exciting. Why is it such a dramatic decision? Well, for a number of reasons. First, because the German Constitutional Court tells the ECB to get its act together, tells the Constitutional Court to go and do a decent proportionality assessment. Now, if you just think about that, it's already remarkable that the German court is criticising the ECB, remember, independent central bank, and the German court is telling the European Central Bank what to do. But even more remarkable, perhaps, or as remarkable certainly, is the fact that the German Constitutional Court lays into the European Court of Justice and says that they're very bad at their job too. It says that the judgment of the European Court of Justice, which is of course the Supreme Court of the EU, is not comprehensible. Why is that relevant? Because the European Court of Justice had been asked to rule on the same programme, and in a decision called Vice, the Court of Justice had upheld that programme. And there was actually a lengthy discussion of the proportionality principle, but the Bundesverfassungsgericht said just it wasn't good enough. It had failed to take into account all sorts of relevant, irrelevant considerations, and therefore it wasn't comprehensible. Therefore, it was not the German court wasn't being bound by it. What the implications of this? Well, there are many. We've already seen some of the implications for the independence of the central bank. But there are also implications elsewhere. There are implications for the Commission. What's the Commission going to do about it now? Is the Commission going to bring enforcement proceedings against Germany for not complying with EU law, and for their Supreme Court, their Constitutional Court, for not complying with EU law? What's the ECB going to do about this decision? Are they going to bow to the German court and do a further proportionality assessment? That in itself would be remarkable. But if they don't do what the German court says, then the German court has said to the ECB, you've got 3 months, and if not, German institutions can't participate in this. And then what about for the Court of Justice? The Court of Justice has been, it must be said, publicly humiliated. And also what you're seeing is the German court saying when the things get difficult, the German constitution and the German Constitutional Court will take precedence over anything that the ECJ and EU law says. That's pretty serious. What's that mean for the primacy of UK law? Sorry, for the primacy of EU law. And that means the Court of Justice came out pretty quickly with a statement saying actually EU law is supreme, but nevertheless you've got this being contested by the German Constitutional Court, and then you've also got implications for EU law as a whole. What happens when you have states not complying with the EU law, because that means you'll have Europe bits and pieces, states picking and choosing the bits of law that they want to. And there are implications too for the Eurozone. What does it mean for Corona bonds, i.e. these attempts to try and finance countries like Italy and Spain, which have been so badly affected? And then perhaps most sensitive in a number of member states is if the German Constitutional Court isn't complying with EU law, what does that mean for the Polish courts and for the Hungarian courts and for the British courts? Do they have to comply with EU law? And it's striking in the newspapers at the weekend. The Sunday Telegraph said it's terrible that the UK is in this period of transition. We're a rule taker, and we're a rule taker from the Court of Justice, which the German court has already said is making bad decisions. So all of this is complicated economically, legally, and also politically.
Speaking from the perspective of Poland, where I am at the moment, we've already seen certain judgments of the Constitutional Tribunal here that have been dismissed by politicians saying, oh, that wasn't really a judgment. They weren't the right judges. It wasn't in their power. So is there a danger of this kind of dialogue being repeated at an EU level? And if this impasse continues to exist between the German court and the Court of Justice, then where do you see this headed?
I mean, it's not good news. I mean, the timing of the decision of the German Constitutional Court really couldn't have been worse for the EU, because it's essentially the German Constitutional Court, one of the most respected courts in Europe, is saying we will not put up with the ECJ not doing a decent job and acting beyond their powers. And of course, if the most respected court in Europe can say that, then other courts may well follow suit and say, well, if the German courts aren't complying with EU law because they think the Court of Justice isn't up to it and issues incomprehensible judgments, then we, the Polish courts, don't need to follow what the ECJ says either.
And as I haven't read any of the relevant law behind this, and I haven't read the judgments. Is there any substance in the allegation made by the German Constitutional Court that the European Court of Justice was overstepping its boundaries?
It's complicated. It's interesting. There's been a battle of the press releases since the judgment. After the judgment, the Court of Justice issued a very terse press release saying EU law takes precedence. This was followed up by the European Commission that also said EU law takes precedence. And then the juge rapporteur, the reporter in the reporting judge in the German Constitutional Court, he said, he did an interview in the German newspapers to explain his judgment and say actually it wasn't intended as a criticism of the ECJ. It was just important for a clear statement that in this question of competence, which is who has the final say on the outer limits of EU law, that the German court should have their say, or national courts should have their say, because the EU is not a federal state, and the member states remain masters of the treaties. Those are the words of the German Constitutional Court. Meanwhile, the president of the German Supreme Court comes out and says, actually, this is a terrible judgment. And he actually makes some rather valid points, legal points, criticizing the judgment, leaving aside the political concerns. But he says, all this talk about competence, how does that tie in with the principle of proportionality? Competence is about, does the EU actually have the powers? Proportionality is about the use of those powers. And it seems odd to conflate the two. And so all of this creates an awful lot of noise, a lot of tension, a lot of concerns. And it makes life very difficult for the ECB as to what to do. But also it has an effect on the markets, because the markets are jittery that even an attempt to do something like corona bonds, well, they will be challenged too. And some people say that maybe the PSPP judgment is the culmination of years of frustration by the German Constitutional Court. They've managed to more or less keep a lid on it up until now. But another way of looking at it is a shot across the EU's bows in respect to corona bonds, because the fundamental question is, what is the Eurozone about? Is it about monetary union? That's what it seems to be, that's what it says on the tin. Or is it about economic union? And of course, the EU doesn't have power at the moment over economic union. Economic policy issues have long been an issue for the member states. The trouble is, it's not as easy as it looks to divide monetary policy from economic policy.
Absolutely. Well, with that, it's hardly out of the way. I presume we're at the beginning of that story rather than the end of it, but we'll have to see how that develops further. Whereas Brexit has happened, the date at least has passed. The UK is no longer a member of the EU. But now we're in this period of so-called transition, the transitional period that is presumably going to expire at the end of December. Now, what happens during that transitional period, and what happens afterwards, and where are we at the moment?
You're absolutely right. So the UK left the European Union, ceased to be a member state on the 31st of January 2020. And we left, it was an orderly Brexit in the end, despite all the fears about a no-deal Brexit. It was an orderly Brexit on the basis of the Article 50 text, the so-called withdrawal agreement. The withdrawal agreement paved the way for transition. And under transition, the UK is de facto a member state. And so it is bound by all of the obligations under EU law. However, it won't participate in any of the EU institutions. Now, the original plan was that there would be 11 months to negotiate a free trade agreement, which would come into force at the end of 2020, when the transition runs out. But best laid plans and all of that, of course, nobody saw coronavirus coming. And the dramatic implications of coronavirus, dramatic in terms of the horrendous death toll, but also dramatic effect on the lives of everyone in terms of the lockdown, the fact that essentially the country has been put in the deep freeze for a couple of months. And of course, it means that negotiations over the future trade deal have almost not taken place. The lead players, both themselves contracted coronavirus, which further slowed matters down. So Michel Barnier on the EU side and David Frost on the UK side. The negotiations have been conducted online, but all of those who are experienced in trade negotiations say this is a hopeless way to negotiate. What's really crucial are the deals done in corridors, and it's very difficult to do any deal on the corridor of Zoom. And so the negotiations have been inching forward, or perhaps inching back might be a better way of putting it, because the two sides are at loggerheads. The EU has taken the UK at its word and has proposed quite a comprehensive trade deal, but with significant conditionality. In other words, that the UK has got to comply with EU rules on state aids, on level playing field matters, that's social, environmental and consumer rights, and also in respect of, well, they want to deal on fisheries, which is essentially status quo, and they want ultimate jurisdiction of the Court of Justice. UK says, well, look, we're a sovereign state. We're not going to be kicked around by you, the EU. we don't want to agree to any of those things. So at the moment, we're in a dialogue of the death. This is crucial. Yeah, I was going to say this is crucial because the negotiations are going nowhere, both literally and metaphorically, and the time is running out. Now, the Freight Haulage Association and other key players are begging the UK government to have an extension to the transition period. As they say, we have all of our capacity is devoted to dealing with COVID at the moment. We can't deal with Brexit as well. UK government seems to be at the moment disposed to a no trade deal Brexit at the end of the year, falling back on WTO terms, and any of the economic hit that will be taken from that will be wrapped up in the losses generated by COVID.
And at the moment then, so on the 1st of February, from the 1st of February onwards, when the UK is no longer a member, and during this transitional period, there is what we call retained law. So in essence, all EU law continues to apply. What was the idea behind that, and what is the plan for what happens to this EU law, which has somehow changed nationality so that it's become British, but it hasn't changed in terms of content?
So what we've got is actually two things. You're absolutely right, we've got retained EU law, but that kicks in actually at the end of transition. Before that, we're carrying on with EU law as it is, but the conduit pipe of EU law into UK law is not the original European Communities Act, 1972, the act that took us into the EU, but a different piece of legislation, namely the EU Withdrawal Agreement Act of 2020. But nevertheless, they more or less do the same thing. At the moment, EU law applies, so principles of supremacy and direct effects still apply. At the end of the year, if there is no trade deal, then the whole body of EU law becomes, as you say, EU retained law. It becomes part of UK domestic law, but it will be domesticated. In other words, it means that we'll carry on applying it for legal certainty, but it can be altered at any time by the UK government, because that's, of course, what those who voted Brexit asked for, to take back control.
And will that apply to things such as the Charter of Human Rights?
No, that's one of the major exceptions to this principle of continuity. The Charter will be turned off at the end of the year. However, where the Charter embodies general principles of law, those general principles of law will continue to apply.
So we're presumably talking about thousands and thousands of pieces of law, directives, regulations, decisions. And at British Law Centre, students are very often point out that statistically speaking, the British Parliament adopts very, very few statutes in comparison with their parliaments. So how is Parliament supposed to deal with these huge areas of law and the thousands of pieces of written law that may need to be changed?
Yeah, so nobody quite knows how much EU law there is, but some people say it's about 20,000 pieces of legislation. Of course, the trouble is it's a very misleading figure, because if you look at the regulations, a lot of those regulations might be extending the application or corrections or that sort of thing. So it's very difficult to know how many pieces of EU legislation there are. But you're absolutely right. And it may well be that whole tracts of EU law, called EU retained law, will carry on applying in the UK for decades hence. And indeed, that's the experience of countries that have got independence from the UK. The application of essentially empire, UK enacted legislation, carries on for decades, because the governments either haven't got the capacity or the desire to amend law in that particular area.
Well, I'm sure, since we're in the pre-exam period, I'm sure that your students feel like there's an enormous amount of EU law out there that they need to learn. And perhaps that brings us on to another issue. We can return to the EU perhaps later, but you are senior tutor at one of the colleges in Cambridge, and the COVID-19 situation has impacted on the BLC, on every university in Europe. So what are there any plans for life after Brexit, life after COVID-19, and if so, how are institutions planning to adapt to the challenges that are presented by the current situation?
Yes, it's certainly a complex time to be heading up one of the larger institutions in Cambridge. So we've got the major challenge at the moment, of course, is coronavirus. We shut the college on the 13th of March, slightly ahead of when the government ordered a lockdown. And our students had to return to their own homes very quickly, and that obviously put them at a lot of inconvenience. Since then, we've been dealing with the fallout of all of that, of which there has been quite a lot. But crucially, we had to make preparations for the start of the new term and teaching online. And actually, to my pleasure, I think an awful lot of academics have successfully been able to adapt to the Zoom life. Not necessarily with great pleasure, but I don't know how many of us probably talked about the verb to Zoom until about 8 weeks ago. But now we do it all the time, both in our professional and social lives. And indeed, for the first time ever in the university's history, we're having online exams, and an entire new way of examining has been developed again in really a very short period of time, quite dramatic for a university as old as Cambridge. And what we're talking about at the moment is how we're planning for the start of the next academic year, and how we might address the coming out of the lockdown, the exit strategy, just in time for the UK's own final exit strategy from the EU. And that's where the other bit of my life feeds into my senior tutor world, because if we leave with a no trade deal Brexit, I think there'll be considerable hardship in January and February. I think at the moment, hauliers have been able to more or less meet the demands caused by the lockdown. But that's because we're still in the EU and goods still move freely across frontiers. The extraordinary issue about Brexit is, for the first time ever, a country is making itself more distant from its closest trading partners and putting up barriers to trade rather than taking them down.
And so do you think that the double whammy, as it were, of Brexit and COVID-19, I suppose a triple whammy if we throw into the mix some of the Supreme Court judgments from recent years? I'm thinking particularly the Miller 1 and Miller 2 judgments. Do you think all of this could collectively create a package that has a lasting change on the UK Constitution and how it functions?
I think what we learnt from Miller 1 and perhaps from Miller 2 is that our constitution is flexible, but will try and withstand a serious challenge by the executive. But I think what we also see is that some people say, well, those cases indicate the UK needs a written constitution. I'm not so sure, because it's not at all clear to me having a written constitution would have resolved those problems anyway. And of course, ultimately, a written constitution doesn't actually protect you from totalitarian governments, although it does send out a strong statement of principle. I think we saw courts being quite brave in the face of considerable attack from the parts of the British media. But what's so interesting is we've learned a great deal about our own constitution. I think we've learnt that actually when we're talking about government in the UK, normally we're talking about majority governments, and therefore the role of the executive and the legislature essentially operate hand in glove. What was unusual in that autumn, that messy autumn period, is where the government, the executive, did not have a majority in Parliament. And so the executive and the legislature did not operate together. And indeed, there was a concerted effort by disenchanted Tories, combined with the SNP, the Scottish National Party, combined with large parts of the Labour Party, but not all of it, to really try to stop at least a no-deal Brexit, which at the end of the day they did manage, but not through parliamentary manoeuvrings. But then we have an election in December. There hasn't been an election in December in the UK since the 1920s, for the simple reason that, like Poland, it's cold and wet in December. and lots of people don't want to go out to vote, but nevertheless we did have an election and it didn't snow, people came to vote and they voted overwhelmingly in favour of a Conservative government. So we're much more now back into business as usual territory, where the executive and the legislature operate hand in hand, because the executive, the government, Boris Johnson's government, can tell all of the MPs, he's got a majority of 80, which way to vote, and for lo, they vote that way. So that's why Brexit could be delivered in a way that Theresa May wasn't able to do.
And the judiciary, having been somewhat of a thorn in the government's side in recent years, then what instructions, legislative instructions or guidance, have the judges been given about how to interpret what will now become British law, but its origins were in the EU, and perhaps ECJ case law has developed it further? What would be the relationship?
Yep, so the instructions they've got are those in the 2018 Act, the EU Withdrawal Act. And yes, the judges are told that they've got to apply pre-Brexit decisions of the Court of Justice, and those have hierarchically superior effect. But in respect of post-Brexit judgments of the Court of Justice, they can apply them if relevant. But crucially, in respect of both pre and post-Brexit decisions of the Court of Justice, if the UK government doesn't like which way the British courts go, then they can pass an act of parliament to reverse that decision. They won't be bound by the principle of supremacy of EU law.
Well, I remember the last time that we met in Warsaw, you were giving us an analysis of the withdrawal agreement even before the ink had dried on it. It seems like every time we speak, something new has erupted that requires commentary. So I'm extremely grateful that you find the time for us to comment on these things and to keep that strong contact and support that you've always given us for the British Law Centre. On behalf of myself and my colleagues at the BLC and all of our students, thank you so much for joining us. We follow all of your work, both published within the faculty and of course in the UK in a changing Europe. And I don't know when you sleep. I have serious doubts that you ever do, because your Twitter account is constantly active. So we will do our best to follow you, but I occasionally have to have an hour's sleep. So if there's a little bit of a gap in my comments, then please forgive me. So thank you so much for joining us. Stay safe during this period, and we hope to see you face to face, and we won't need to Zoom in the future, because of course you'll always be welcome, and I hope you'll always want to come back to us at the BLC.
Thank you very much indeed, and I must say it's fantastic the work that the BLC has been doing for so long now, and I really look forward to seeing you back in person.
Thank you so much.